So this is part 8 of company law problems and solution. Chairman. A general meeting of the company is to be presided over by a chairman who regulates and supervises the proper conduct of the business at the meeting. He decides all incidental questions arising in the course of the proceeding of the meeting. Chairman should act bona fide and in the best interest of the company as a whole. Articles usually provide the mode of appointment of the chairman of a meeting. If the articles do not provide otherwise, the members personally present at the meeting shall elect one of themselves to be the chairman thereof on a show of hands, and that is discussed in section 104. So, this is discussed in section 104. Now, if a poll is demanded on the election of the chairman, it must be taken forthwith, and the chairman elected on a show of hands can exercise all the powers in this connection. That is 104 subclause 2. Now, the 104 subclause 1 speaks about that the members personally present at the meeting shall elect one of themselves to be the chairman, therefore on a show of hands. That is discussed in section 104 subclause 1, and in 104 subclause 2, if a poll is demanded on election of the chairman, it must be taken forthwith, and the chairman elected on a show of hands can exercise all the powers in this connection. If some other person is elected chairman as a result of the poll, he shall be the chairman for the rest of the meeting. Now, chairman of the original meeting shall be the chairman of the adjourned meeting also, unless validly removed. The chairman of a meeting may be appointed by the company law board or tribunal in case where there are difference among the shareholders, and peaceful meeting under the chairmanship of a person appointed by either group is impossible. So, chairman of the original meeting shall be chairman of the adjourned meeting also, unless validly removed. The chairman of a meeting may be appointed by company law board or tribunal in case where there are difference among the shareholders, and a peaceful meeting under the chairmanship of a person appointed by either group is impossible. Now, casting vote. Articles of association may give an additional or second vote. The articles of association may give an additional or second vote to the chairman of the company over and above his right to vote as an ordinary member. In the case as of a tie, equality of votes, chairman may use the casting vote to decide the matter in one way or the other. Now, a problem. A proxy was appointed by a member on an instrument duly executed. Will the vote cast by the proxy be valid in the following situation? That is, when the member himself attended and cast his vote at the meeting without revoking the authority of the proxy. So that we already discussed Cousins versus International Bricks Company, and the proxy stands revoked. And if the revocation was not communicated before the commencement of the meeting, we have to apply the decision of Spiller versus Mayo Rodenstina Development Company, where it was said that revocation may be too late if communicated after the meeting has commenced. In such a case, the votes cast by the proxy will be valid in a poll. So we have two case laws with respect to this: Cousins versus International Bricks Company Limited and Spiller versus Mayo Rodenstina Development Company Limited. The next problem is that Prosperity Limited issued a notice of its annual general meeting to be held on 7th November 2016. The notice was posted on the members on 16th October 2016. A few members of the company alleged that the company had not complied with the provisions of the Companies Act with respect to the period of notice, as such, the meeting was not validly called. Decide giving reasons. Three reasons or three questions are asked. Three issues: whether the meeting has been validly called. Second one is the notice short than the mandatory requirement, and the third, can the shortfall be condoned? So the solution to this: for a general meeting, at least 21 days clear notice is required. The day of the meeting and the day on which the notice is issued to be excluded. If the notice is sent by post, another 48 hours are to be added. In the case the meeting has not been validly called, as the notice falls short by 2 days, it can be condoned if all the members entitled to vote at the meeting give their consent. Now, length of notice. A proper notice in writing or through electronic mode to every member of the company is required by law for holding of every valid meeting. Notice must be given even though a member has waived his right to have notice. It must disclose the purpose for which the meeting is called. It must be given at least 21 clear days before the date of meeting. In calculating 21 days, the date of receipt of the notice and the date of the meeting should be excluded, and that is given in section 171 subclause 1. The gap should be of 21 clear days. The notice shall be deemed to have been received by a member at the expiry of 48 hours from the time of posting. In case of newspaper advertisement of a notice, the period of 21 clear days begins from the day after the issue of the newspaper. Articles may provide for a notice longer than 21 days but not shorter than 21 days. Now, calling a general meeting by a shorter notice. Here, two instances are discussed. The first one, an annual general meeting may be called at a notice of less than 21 days with the consent of not less than 95% of the members entitled to vote at the meeting. And the second scenario is an extraordinary general meeting may be called at a notice of less than 21 days with the consent of majority in number of members entitled to vote who are present, not less than 95% of paid up share capital carrying voting rights at the meeting. In case of company not having share capital with the consent of members holding not less than 95% of the total voting power exercisable at the meeting. Now, the next problem is, so you have to look into section 171 with respect to that. And now, the next problem, the company sends a notice to call an annual general meeting on 1st December 2012. The notice is posted to the members of 15 members on 15th October 2012. On 25th October 2012, the central government declared 1st December 2012 as a public holiday under the Negotiable Instruments Act 1881. Can the meeting be held as scheduled? So it was to be conducted on 1st December and the notice was given on 15th of October. On 25th of October, central government declared 1st December 2012 as a public holiday under Negotiable Instruments Act 1881. Can the meeting be held as scheduled? Solution. The declaration by the government was notified after the issue of the notice convening such meeting. Therefore, the meeting can be held as scheduled. So that is the solution. Since the declaration of the government was notified after the issue of the notice convening such meeting, the meeting can be held as scheduled. So the next problem we have here is, one general meeting was called by a company in December 2012. The meeting was adjourned to March 2013 and then held. Subsequently, meeting was held in February 2014. Subsequently, meeting was held in February 2014. Is the company liable for any irregularities? So we have a case law here, and that is Sri Meenakshi Mills Co. Limited versus Assistant Registrar of Joint Stock Companies. Once again, Sri Meenakshi Mills Co. Limited versus Assistant Registrar of Joint Stock Companies. So I'll read out the problem once more. One general meeting was called by a company in December of 2012. This meeting was adjourned to March 2013 and then held. The subsequent meeting was held in February 2014, so almost a year later. Is the company liable for any irregularity? So the relevant case law here is Sri Meenakshi Mills Company Limited versus Assistant Registrar of Joint Stock Companies, and the relevant section is section 96. Section 96 of the Companies Act 2013 requires a company to hold its annual general meeting every calendar year. So there should be one meeting per year and as many meetings as there are years. Thus, in the above case, the meeting held in March 2013 is actually the meeting of December 2012. Since next meeting is held only in February 2014, the meeting of 2013 has been missed. Under these circumstances, unless permission of the registrar was obtained for the extension of time, which may be granted up to a period of 3 months, under certain special circumstances, the company shall be proceeded against. Now, the next problem. the annual general meeting of XYZ Limited for financial year ending in 31/3/2013 was held on 27/9/2013. But since the financial statement had not been audited, it was adjourned and finally held on 31/3/2014, at which the audited financial statements were adopted. The annual general meeting for the previous year had been held on 29/6/2012. Decide whether holding of the general meeting on 31/3/2014 for the year ending in 31/3/2013 is valid. So the facts of the problem is based on the case of Bijay Kumar Karnani versus Registrar of Companies. Once again, Bijay Kumar Karnani versus Registrar of Companies. So once again, I will read out the question. The annual general meeting of the company for the financial year of ending in 31/3/2013, that was held on 27/9/2013. So it was held nearly 6 months after the financial year ending of the financial year. But since the financial statement had not been audited, this was adjourned to 31/3/2014. So the financial year ended in 31/3/2013, though the meeting was has put on 27/9/2013, it was adjourned to 31/3/2014, at which the audited financial reports were adopted. Now the annual general meeting of the previous year had been held in 29/6/2012. So the gap between both the annual general meeting is 29/6/2012 and 31/3/2014. Decide whether holding the annual general meeting on 31/3/2014 for the year ending 31/3/2013 is valid. So if there was no adjournment, the gap would have been 29/6/2012 and 27/9/2013. But since the meeting was adjourned, the gap became 29/6/2012 and 31/3/2014. And the relevant case law here is Bijay Kumar Karnani versus Registrar of Companies. In this case, the court held that even adjourned annual general meeting of a company inter alia must be held within 15 months of the previous meeting. The meeting of 31/3/2014 is therefore not valid. So once again, in this case, court held that even the adjourned annual general meeting of a company inter alia must be held within 15 months of the previous meeting. The meeting of 31/3/2014 in this case is not valid. Now the next problem, that is Reliance Industries Limited has its registered office at Mumbai. The company decides to hold an extraordinary general meeting in New Delhi. Examine the validity of the company's desire with reference to the relevant provisions of the Companies Act. So the solution here, there is no specific provision in the Companies Act which prohibits the holding of an extraordinary general meeting at a place other than the registered office or place outside the town, city or village in which the registered office is situated. Thus, unless the articles of association of the company provide otherwise, it is legally possible to call an extraordinary general meeting of the company in New Delhi. Now, place of the meeting. Annual general meeting. The annual general meeting is to be held by a company at its registered office or at some other place in the same city, town or village where the registered office of the company is situated. However, the central government has the power to grant exemption to any company from this provision. A private company and an unlisted company can hold its annual general meeting at any other place if two conditions are met. The first condition, it has fixed the place of the meeting by the articles. Or the second condition, it has fixed the place of meeting by a resolution agreed by all the members. Now that is with respect to annual general meeting. Now with respect to other general meeting. There is no such provision in the Companies Act which requires that the general meetings of the company other than the annual general meeting must be held at some particular place. It therefore follows that the other general meetings can be held subject to any specific provision in the articles at any other place. However, the directors must act reasonably in fixing the time and place of the meeting so that the members get full opportunity in exercising their voting rights. Now towards the next problem. An annual general meeting was called by a company in December 2014. The meeting was adjourned to March 2015 and held at that time. Subsequent annual general meeting was held in February 2016. Is the company liable for any irregularity? Discuss stating the provision of the Companies Act with respect to the time within which annual general meeting should be held. As per the Companies Act, there must be one annual general meeting in every calendar year. In this case, the meeting in 2015 is the continuance of the earlier meeting of the year 2014. Company would be liable for not holding meeting in 2015. The next problem, a company has 100 members. It sent notice of the general meeting to all of them. 20 members do not attend the meeting. Out of the 80 members who are present, 20 abstain from voting. How many members should vote in favor of a resolution if it is to be passed as a special resolution? Now, as per section 114 subclause 2, once again, section 114 subclause 2, for a valid special resolution, votes cast in favor must at least be 3 times the votes cast against the resolution. So, vote cast in favor must be at least 3 times the votes cast against the resolution, if any. Those who abstain are not to be counted. Thus, 3 by 4 of 60, that is at least 45 members must vote in favor of the resolution. For special resolution, those who are present and voting. So, those who are abstain is not calculated, and those who are not present is not calculated. From those who are present and is voting, 3 by 4th of the majority should be attained for a resolution to be passed in, for a proposal to be passed in special resolution. So here, out of 100 members, 20 are absent. So only 8 are present. 80 are present. Out of the 80 present, 20 abstain from voting. So only 60 members are voting. So out of the 60, one needs the proposed resolution needs at least 45 votes in favor for it to be passed under special resolution. So the next problem, Mr. P and Mr. Q, who are directors of the company, informed their inability to attend a board meeting because the notice of the meeting was not served to them. Discuss if there is any default on the part of the company. So the solution, notice should be given to all directors even if the directors preclude themselves from voting on a proposed business. The next question, Mr. X, a director who resides in Bangalore, was served notice when he visited the company and not at his usual address. Are the resolutions passed in the board meeting valid? The solution, notice to a director can be given by hand delivery also. So the notice given by hand is a valid notice. Resolution passed at the board meeting are also valid. And then the next problem we have is, the chairman of Evergreen Limited convened a board meeting and 2 weeks notice was served on all directors of the company. 2 of the independent directors on the board objected on the ground that no proper agenda for the meeting was circulated. Comment. The solution is that the board can transact business even without a formal agenda. The contention of the independent directors is not valid in this case, and the same case was discussed in part 1 of the company law problems and solution 2. Now, the directors of Infotech Consultants Limited, registered in Kolkata, proposes to hold the next board meeting in May. They seek your advice in respect of the following matters. 1. Can the board meeting be held in Chennai when all the directors of the company reside at Kolkata? Second, can the board meeting be called on a national holiday, and that too after business hours, as majority of the directors of the company have gone to Chennai on vacation? So the solution here is, any convenient place is permissible, and board of directors meeting on national holiday is permissible unless articles of association provide otherwise. And the next problem we have is, a board meeting was called on a national holiday but was adjourned for lack of quorum. The board fixes another date for the adjourned meeting, but it is a national holiday. Comment. Now, here the relevant section is section 174, and it implies that while the original meeting of the board meeting can be held on a national holiday, the adjourned meeting for want of quorum cannot be held on national holiday. Once again, it implies that while the original meeting of board can be held on a national holiday, the adjourned meeting for want of quorum cannot be held on national holiday. However, the adjourned meeting for reasons other than for want of quorum can be held on national holiday. So it depends on why the meeting was adjourned. If it is for want of quorum, that cannot be adjourned to a national holiday. But the board has no power to fix another day or place or time for such adjourned board meeting. Whereas in the case of a general meeting, the board can adjourn it to any other time and place, and board meeting can also be held on a national holiday unless articles of association provide otherwise. And the next problem is the auditor of a company wanted to see the minutes book of directors meeting. The chairman of the company refused on the ground that the matters of confidential nature were contained therein. Advise the auditor. So the solution, under section 143 subclause 1. Section 143 subclause 1 of Companies Act 2013, the auditor of a company has the right of access at all times to all books and information which he considers necessary for the proper performance of his duties, even though the information is of a confidential nature. He has accordingly a statutory right to inspect the director's minutes book. In case he is denied access to it, he should state that in his report along with the reasons therefor. The board of directors are bound to give the full information and explanation in their report on account of the company on every reservation, qualification or adverse remark contained in the auditor's report. Now the next problem, in a board meeting, a few directors raised disagreement on the minutes of the earlier board meeting, alleging that the decisions were recorded wrongly. Advise the chairman. So the solution, the minutes of a board meeting once recorded cannot be changed. However, at the current meeting, the disagreeing directors, with the permission of the chairman, may move a motion for passing a resolution modifying the earlier resolution recorded in the minutes which they feel have been wrongly recorded. So, the minutes of a board meeting once recorded cannot be changed. However, at the current meeting, the disagreeing directors, with the permission of the chairman, may move a motion for passing a resolution modifying the earlier resolution recorded in the minutes which they feel have been wrongly recorded. Now, the next problem, during the year 2013, A Limited held 4 meetings of the board on 2nd Jan, 10th May, 16th October and 31st December. Examine whether this was in accordance with the provisions of the Companies Act 2013. As per section 173 of the Companies Act, in case of every company, its board of directors shall hold at least 4 meetings every year in such a manner that the gap between 2 consecutive meetings is not more than 120 days. In the present problem, the gap between January and May meeting and likewise between May meeting and October meeting has been more than 120 days. Hence, section 173 has been violated. And the next is with respect to managing director. Now, a managing director was removed during the tenure of his office and certain compensation was paid to him. It was later on found that during the tenure of his office that he was guilty of corrupt practices and the company felt that no compensation should have paid to him and therefore wants to recover the compensation so paid to him. Can the company succeed? So, the Companies Act 2013 does not provide for the refund of any compensation paid by the company to its managing director, whole-time director or manager. So, it only lays down the situation under which no compensation is payable for loss of office, and one such situation is the commitment of fraud or breach of trust by the director. So, there is a case law here, that is Bell versus Lever Brothers. Once again, Bell versus Lever Brothers. Lever Brothers removed their managing director of a subsidiary by paying him compensation. It was afterwards discovered that during his tenure of office, he had been guilty of so many breaches of duty and corrupt practices that he could have been removed without compensation. An action was then commenced to recover back the compensation money. It was held that Bell was not bound to refund the compensation money and to disclose any breach of his fiduciary obligation so as to give the company an opportunity to dismiss him. The managing director is not bound to refund the compensation, hence the company cannot succeed. The next problem, Mr. Suresh, an additional director appointed by the board of directors of public company, is proposed to be appointed as a regular director in the annual general meeting. Explain the requirements under the Companies Act 2013 to give effect to the proposed appointment. Now here the relevant section is section 161 subclause 1. Section 161 subclause 1 of Companies Act 2013 provides the provision relating to additional directors in accordance with which additional directors will hold office up to date of the next annual general meeting or the last date on which such annual general meeting should have been held, whichever is earlier. Therefore, additional director cannot be treated as retiring director. Hence, to appoint Mr. Suresh, an additional director, as a regular director, provision of section 160 need to be complied with. So, an additional director is not treated as a regular director. So, to appoint Mr. Suresh as an additional director as a regular director, provision of section 160 need to be complied with. So, the next problem is ABC Limited intends to appoint Mr. D as an alternate director in place of Mr. X, who has gone abroad for 1 year. But there is no provision in the Articles of Association authorizing the board to appoint alternate director. State the legal position. So here the relevant section is again section 161. Section 161, if the articles do not authorize, shareholders may authorize the board of directors by passing an ordinary resolution. So it is up to the shareholders to pass an ordinary resolution empowering the board of directors to appoint an additional director. Now, alternate director. The board of directors of a company may, if so authorized by its article or by a resolution passed by the company in general meeting, appoint an alternate director to act for a director during his absence for a period of not less than 3 months from India. However, a person holding any alternate directorship for any other director in the company shall not be appointed. Again, a person who is already a director of the company cannot be appointed as an alternate director for another director in the same company. So there are two instances, that is, a person holding an alternate directorship for any other director in the company shall not be appointed as a regular director, and a person who is already a director of the company cannot be appointed as an alternate director for another director in the same company. An alternate director is not an agent of the original director. Now, no person shall be appointed as an alternate director for an independent director unless he is qualified to be appointed as an independent director under the provisions of the Act. The next topic is related to political contribution. So, the board of directors of a public company in the private sector, having made an average net profit of 1 crore rupees during the last 3 financial year, proposes to donate during the current year a sum of 4 lakh to a political party. Advise the board of directors about the power in respect of the above, explaining the relevant provisions of the Companies Act. So here the relevant provision is section 182 of Companies Act, which deals with the political contribution. Board of directors is empowered to contribute to a political party up to 7.5% of its average net profits during the 3 immediately preceding financial year. Section 182 subclause 1 says that the government company and a company which has been in existence for less than 3 financial years are not eligible for making a political contribution. That is, only companies which are not a government company and having the existence of more than 3 financial years is eligible for making a political contribution. Company is required to pass board resolution at the meeting of the board of directors for such contribution. We still have a few more problems to discuss, and that will be in the following parts. Thank you for listening and stay tuned.